what was striking to me about this decision was not so much, there's been a lot of attention to the fact that Sean McCutcheon, who was the plaintiff in this case, was complaining about the fact that he could only give $123,000 in federal elections to candidates. And now after this decision, he'll be able to probably give $3.5 million or more. And there's also been some attention, Heather touched on this, that the court has has gotten to the point where they've limited the definition of corruption so much, and that's the only basis, the court says, for regulating money in politics, that basically you have to have an American hustle situation now where there's a suitcase full of cash, a video camera, and an exchange for legislation being passed. But what was most troubling to me about this case is not either of those things, but really what the court has communicated is now its vision of our democracy, and that goes beyond the specific implications of this case. And there are three things that I would point to that were particularly troubling in this case that points to, I think, some dangerous, potentially dangerous decisions down the road. I do want to say I am going to get to a silver lining along the lines of what Heather was discussing, but I think it's really important to understand in some ways just how radical this decision was. The first thing is, the court didn't just say that buying access and buying influence is okay. They actually said that it is constitutionally protected. In talking about buying access and influence, Justice Roberts says, this embodies a central feature of our democracy. And related to that second point that was very troubling to me is that the court completely elides the difference between donors and constituents. Mm-hmm. So Sean McCutcheon, who wants to, and now will be able to write $2,500 checks to every political action committee and every candidate in Oregon and Washington State and New York State and Minnesota, lives in Alabama. The court says once he writes a $2,500 check to those folks in all those other states, he's a constituent, and in justifying protecting his rights to make those checks, they really make clear what their vision of our democracy is. They say constituents have the right to share their views and concerns and responsiveness to those constituents. And again, when they're talking about constituents, they mean Sean McCutcheon, the very few people who can write checks like that. Responsiveness to them is the key to the very concept of self-governance through elected officials. And the third thing that I want to talk about, again, related to these first two, is that the court makes clear that they care a lot more about this very small minority in our country than voters in general. And I was struck by the fact that the court opens the decision by talking about the ways that citizens can participate in our democracy. And Justice Roberts says, there's no right more basic in our democracy than the right to participate in electing our political leaders. And he goes through a list. He starts with voting, and he ends with making a financial contribution to candidates. The court then proceeds to bend over backwards to prevent any infringement on that right to make as much of a contribution as Sean McCutcheon wants, the maximum amount to every candidate in Congress. And they imagine various scenarios, not necessarily that are currently written into the law, that would prevent corruption, that would prevent Sean McCutcheon and candidates from circumventing what are called base limits. If you contrast that with the cases that they've decided on voting recently, like for instance Crawford, the voter ID case, where there's a real actual burden on voters, right? That case was about requiring a specific kind of voter ID, that a specific kind of identification card, government-issued ID that some voters don't have. The court kind of brushes that aside because they're concerned about potential in-person voter fraud, which they concede in that decision there's actually no real record of in recent history. And they make no effort, as they do in this case, to talk about less restrictive alternatives that could be used so that voters will not have to be burdened to cast their vote. So, all of those things are really striking to me and tell me something about the way the majority on this court thinks about our democracy. And when we talk about equality, I think it's a very different idea of our democracy than the one that Heather detailed. As I said, I do think that there's a silver lining, and that's in the Breyer dissent. Breyer was joined by 3 other justices, and he offers a contrasting view of what our democracy is. And I think, in some ways, for the first time, talks about, he contrasts the court's view of what corruption is and what we're trying to protect against, and he asks, why is it that in these decades of decisions since Buckley in the early 70s, why is it that the court has said we're concerned about corruption? What is it about corruption? And he starts to unpack that a little bit and say, well, we're concerned about corruption, and we say that it is a basis for regulating money in politics because we want to make sure that government is responsive to the people. We want to make sure that there is integrity in our elections, that the voices of a few don't drown out the voices of the many, and that the line of communication between constituents, actual constituents, and their representatives is clear. So I think that that's a very hopeful, the fact that there were 4 justices that signed on to this view, that's a very hopeful thing because, a lot of people talk about the fact, there's been a lot of talk about we need to overrule McCutcheon, we need to make sure that we overrule Citizens United, but the fact of the matter is, the problems that Heather talked about, Citizens United was decided in 2010, the problems that we talk about with money in politics existed in 2009, existed in 2008, they may be about to get worse. But really, we need an entirely new thinking about the rationale for regulating money in politics, and I think Breyer and the other dissenters have started pointing the way for that.